The interpretation of the recent Supreme Court ruling is seemingly as clear as mud.
All the inmates who are under the trial in the General Court Martial, all their matters are now under the jurisdiction of the courts of judicature.
The Deputy Speaker of Parliament, Thomas Tayebwa, invited the Attorney General, Kiryowa Kiwanuka, in the chambers to clarify the issue.
The Ministry of Defense and Veteran Affairs is also advised to immediately commence consideration of the recommendations of the Supreme Court with a view to introducing appropriate amendments to the UPDF Act.
However, some MPs were not convinced, as the Attorney General was a litigant in the case.
The President quoted you, that he called you on phone, and you seem to have given him an advice that does not match with what you are telling us here.
If he was waiting for a decree, what was the basis of his advice? Number two, I am not aware, and he can now educate us, the law under which a losing or vanquished litigant would write to court to ask for which orders.
And yes, and that's why maybe I lost. But what we are saying is that if you disagree with what I have written as what the court said, the arbiter is there.
The Supreme Court exposed the illegality of the court-martial to try civilians.
Also, when we say the Attorney General has guided the House wrong or what, we are not making any resolution on this matter. I asked the Attorney General to give us an update. This is a matter which has been settled by court.
What the learned Attorney General seems to be saying is that now the court-martial is going to be directing the DPP to say, we have these matters, you take them up. That's against the law.
This comes at a time when some civilians, including former FDC leader Kizza Besigye, are victims.
There's absolutely nothing left for discussion. There's absolutely nothing left for resolution. There's nothing left for amendment.
The controversy deepens as the government awaits clarification on which victim files are to be transferred to the courts of judicature as ordered by the Supreme Court.
It is this a matter of interpretation. And where there is a dispute as per the interpretation, it is not for Attorney General, it's for the court to settle that component. That what do you mean? Because court did not say release. If we are reading it to the dot, the court did not say release. Say immediately seize and transfer. Now, the process of transfer is a process.
The legal team representing Dr. Kizza Besigye, led by Kenyan lawyer Martha Karua, is actively pushing for a detailed schedule and the government's position on implementing the Supreme Court ruling.
Because we all know what should be done. That person should be released immediately because the court always says, unless otherwise lawfully held.
The team spent part of their afternoon at Luzira Prison interacting with prison authorities to discuss the way forward.
They recognize the fact that actually they need some paperwork, a remand warrant, to continue keeping Dr. Besigye in their custody. But unfortunately, they claim their hands are tied, that they are waiting for a directive from the Attorney General. And the Attorney General is not giving a directive whether they should continue on remand or they should be.
Despite a recent letter on social media from President Yoweri Museveni disagreeing with the Supreme Court ruling, Attorney General Kiryowa Kiwanuka has assured Parliament that the government has decided to respect the ruling accordingly.
I have rendered advice. I have told you that the government has decided to comply with the court order, and we are going to comply with the court orders as have been given by the Supreme Court.
Daniel Mugoya, UBC News.